Good morning. There are two documents here I want to focus on as we start the week. The first is a document attached called MTD 1070J. This is a motion I filed which seeks to confirm the fact that many cases here in Pinellas County have already been dismissed by judicial order that's recorded in the official record books. The important thing about this motion and this issue is that despite the fact that the court had properly dismissed these cases, after a hearing, the plaintiffs improperly decided to continue with cases, and in some instances may have obtained final judgment and certificates of title even after the case was dismissed. The problem with this is that once that master order of dismissal has been recorded, the case is dismissed and the court has lost jurisdiction. So any final judgment entered after the fact and any certificate of title based thereon is void. We'll be reviewing those cases and uncovering the instances in which this occurred, but it presents a major problem for title insurers across the state. And in fact, the foreclosure mills that in their rush to push all this cases through have created more problems for themselves. The second issue we want to focus on is the new administrative order that was released by the chief judge of the circuit last week, and that is dealing with the new mortgage foreclosure procedures. This circuit continues to lead the state in developing effective programs to deal with the foreclosure problem, and this administrative order reflects a sophistication and an understanding of these issues that, frankly, many other circuits lack. Importantly, the order requires the plaintiffs to have the complaint verified before the case even begins. They're not even supposed to issue a summons before it begins, but even if they do, none of the timelines begin to take effect. So even though the millionaire foreclosure mills continue to file non-verified complaints, this sort of makes it clear that the case isn't going to proceed. Now, I can't explain why these millionaire mills continue to flaunt the Supreme Court order and ignore this, but it's clear that there are going to be consequences for that. In all my motions now, I do a motion to dismiss and increasingly motion to dismiss with prejudice because the case law is very clear. If you're violating rules knowingly, there are sanctions for that. One of the sanctions is that it be dismissed with prejudice. The order contains a lot of other important information, and that is an explanation of the rights that borrowers have to request information prior to going into mediation, and a requirement that lenders verify certain other information like the right to possess the note and proceed with the action, and proper accounting on the complaint. Things continue to go in a favorable direction for foreclosures. Continue to keep up the good fight and call me with any questions.